2015? That's loud. AV. Please, if you are listening, it does not work. Again. Okay. Good morning. Maybe it will come on soon. But I am not hopeful. All right. Well, we'll get started. All right. Great. So, good morning. Your 0L counterparts are filling the hallways. And the question I have is, do they keep you far away from them so as to not dash their hopes? No, right? Who would do that? Just kidding. All right. So, office hours for today. I'm going to go talk to them about cool stuff in the law and tech and fun things like that. Let's see if I can. Can you all hear me okay? Hear me okay in the back? Nods? In the back? Nods. Good. Okay. So, office hours. I will be at a lunch from 12 to 1:30-ish. So probably 1:30 I'll be back. We'll go to 2:40-ish, 2:45 for anyone who's available in that window. I got to then go talk to the admitted students. I'll be back probably around 4:15, and I'm free till 6, at which point I'm going to a seminar. So it's a long day. But feel free to come by during one of those windows, 1:30 to 2:40-ish, or 4:15 to 6. I wanted to read a response to an email I got from a very insightful member of this class who expressed some, can you hear me? Yes? Okay. Some justified frustration with the amount of time they spent reading Section 12 and pointed out that the readings for this class are incredibly dense and lengthy, and justifiably complained over spending more time reading in this class than any other class, on the order of 10 to 15 hours a week, which, you know, supposed to be what you're supposed to be doing for a 4-credit class, but I did feel bad that maybe there was some confusion about like how you should read or what you should be reading. So I just thought I would take the opportunity and read my answer. This person also asked me whether or not you needed to know the rules for the exam. So some of them. So anyway, so I'm going to read my response. So I said, thank you very much for taking the time to write. And this is true, I would say this to all of you, I appreciate you all sharing your candid feedback, and I apologize if the approach to the class is confusing or unclear. Securities regulation is a very detailed area of law with a large number of nuanced and detailed rules. The casebook is over 1,700 pages for a reason. I'm sure you all can understand that it is impossible to discuss every rule, exception, and iteration in the law in the short time we have in class. So my approach is to make sure that you learn and understand the material that is most important for you to get in this setting. In practice, even in practice, you won't be taught all of securities law. You know, when I got to Sullivan and Cromwell, we had some trainings, the very basics of the 33 and 34 Act, but if you're working on an IPO, you're just going to get a checklist that you're going to follow for your particular part of the deal. And so you'll gradually accumulate that kind of knowledge across settings and practice, that sort of very detailed, up-to-date knowledge of the rules. But the question did make me wonder if you would benefit from some guidance on how to read efficiently for the class. So let's take, for example, the material in Section 12, which was in pages 1033 to 1037 of the casebook. That's Section 2G3 on the syllabus. In that section, there are two full-length cases, only two, Pinter Vidal and Gustafsson. And there is discussion after each case, but those are the only two full-length, not even full-length, but reprinted cases in their entirety. The vast majority of the content in those cases, if you just look at what those paragraphs consist of, is more or less reasoning and justification for two very simple holdings. In Pinter, we remember yesterday, the holding of that case is that sellers who are not part of the chain of title can be held liable. But in the case of Dahl not being a participant in the sale transaction in the sense of having some sort of financial gain himself, the court said, look, this particular sort of gratuitous friendly advice would not loop him in to Section 12A1 liability. Okay, that's the holding. That's all you need to know, that any seller who's not in the chain of title can, in fact, be looped in, but they need to have some sort of profit-making purpose. So when you read a case like that, right, you should, like, no partner, this person pointed out it took 3 or 4 hours to read this material, but no partner is going to let you bill 4 hours to read 2 cases. Like, it doesn't work that way. No client is going to pay for 4 billable hours to read 2 cases. So I expect you to develop that skill of just looking for the holding, right? Like, whenever you read a case, I apologize if this seems trivial to some of you, but getting questions like this makes me think it's worth just kind of covering these bases one more time. When you get a case, you don't read it like you read a novel from start to finish, right? You skim sections. You look for the bottom line decision that the court has embraced. You find that, and then you backtrack and read as much as necessary to establish your minimum required understanding of the decision. And that can vary. Sometimes you really want to dig into the reasoning. Sometimes you don't. I want you to come into the class having read at least the holding, being able to articulate what Gustafsson was about, what Pinter Vidal were about, and what those conclusions are. I don't expect you to be able to recite the nuances in the detailed articulations of, the 5th page, 3rd paragraph, number 3 of the opinion, right? I'm also not going to ask you that on an exam, and really nobody cares at some level, right? No law firm partner is going to want you to put into a memo a detailed analysis of paragraph 3 on the 5th page of Pinter. Like, right? Okay, so there are exceptions. Texas Gulf was a case where there was a lot of really important reasoning in that case. So we spent time, but we spent time on it in class, and we spent time on it together. So, what should you outline and study for the exam? Again, we're focusing on the big core issues in securities law. Take yesterday's class. You should make sure you completely understand the analysis we did for the Kylie Jenner hypo, because that's very similar to what you might see on an exam. Okay, that's the sort of question that I would ask you, something like that. And you should make sure you do understand who can be held liable under 12A1 and for what basis. So imagine that I give you a fact pattern, and in the fact pattern you have some sort of communication, like, hey, Michael, there's a deal you can invest in. Let me tell you about it. You know, if you put in $10,000, you know, you are going to be part of the next, like, you know, I don't know, NASDAQ for crypto. I don't know, right? And there's going to be there might be some communication. I'm not telling you what's going to be on the other side. There could be, hypothetically. We're going to have some communication. And it's not enough for you to just say that communication might violate Section 5. Everyone see that? That's not enough. Because if I'm asking you under what bases can I be held liable for that communication to Michael, you need a basis to sue, right? At least in the civil liability setting. We might talk a little bit about the SEC's enforcement authority, and you might have a separate basis for liability there, but what we're talking here, so far in this class we've been talking in the civil liability section about bases to sue, and so your analysis should begin with one of Section 11, Section 12, or many, all of the above, possibly. And you would need to say something like, this communication in violation of Section 5, this communication may give rise to liability under Section 12A1 as a violation of Section 5. There may be an issue as to whether or not I am a seller in that communication, and then you would apply the logic, the holding of Pinter v. Dow in that hypothetical, okay? So you don't, you know, like, it's still law school, so you don't just, like, ignore the law and start talking about whether it's a good idea from an economic theory standpoint to hold me liable. You know, that might come in at the end. But at the same time, I'm not expecting you to give me a Westlaw-style memo on the various views in the circuits as to Section 12A2A1 liability and whether or not a communication of a particular kind is similar to a holding that the District Court of Kentucky, right? Like, that's not what we're doing either, okay? So I just want to make sure this is very, very clear. The scope of the material for the exam is the material we discuss in class. The grading is directly proportional to the amount of time spent on any issue in class. So if you write a detailed essay on some comment after the case, please be forewarned, that will not get credit. It won't. It's not fair because some of you are going to write great essays on issues we're talking about in class, like the kind of analysis that went into Kylie's tweet, and that will get credit. And it's just not fair to treat those two as the same. Okay? Might give you a little bit for trying, but that's it. Okay? So I just want to make sure this is clear, that you don't feel like you were misled, that you're not wasting 20 hours reading 2 cases or 5 cases. Like, you should have spent no more than an hour reading those 2 cases. At most, probably 30 minutes. Like, quick. Get the bottom line, get the key facts, move on. All right? And think about the questions, about the economic questions that are posed, about the policy implications of going down one road or the other. Think about the material, right? Don't just sort of have a long list of details. Any law student can memorize checklists, right? But you go to Columbia, so expect more, right? Okay? Is this clear? Any questions on that? Any questions? Yes, Davia.
And in the future, if you like assign us any other, articles on like economic theories, does the same approach apply, or like, do you do the whole, at least in undergrad, where you just read the introduction and conclusion, find the thesis, and read the introduction and conclusion of each subsequent paragraph within the thing?
For the exam, if you're worried about that, it's just what we discuss in class. That might include something I emailed you, but it is what we discuss in class. Nothing more than what we discuss in class. So if I summarize something in class and spend 5 minutes on it, that means I'd like you to probably mention it if it's relevant, but mention it. If I spend 30 minutes on something, that means it's probably going to be pretty central because it's a really important idea here, right? So just follow the allocation of class time. If you're in class taking notes and listening and engaging, you will have a natural sense, because one of you said to me, like, if I hear one more time some of these things, like you've said them so many times, it's driving me nuts. Like, can we please talk about more things? I don't want there to be any confusion about what matters here, okay? All right, other questions on the course material? This is crystal clear. Yes, Candace. Yeah, great. So the question is, can we get some kind of heads up? To some extent, it's unpredictable. It depends on how our conversation goes, right? And what issues you're asking about in class, what questions you're raising. I think the general roadmap is what I sent out at the beginning of the week. So for this week, we're covering the Howey test today and tomorrow. We're going to talk a lot about what is a security. You need to have read that material. You need to know it. The material in that I sent out an email, the first, subpart, whatever it was, okay? We're going to talk about that today and tomorrow. We'll cover all of that today and tomorrow. How much time are we going to spend on each point? Well, it depends on how this conversation evolves. I can't really predict that. But all you need to do is get the bottom lines, make sure you understand, okay? If I ask you, what was going on in Howey? It's 5 pages of the casebook, guys. It's like 15 minutes to read, right? There's orange groves, there's a deal. You can get maintenance of your orange tree, and there's a 3-part test. It's really simple, right? So I don't want you to spend too much time, and you shouldn't spend an hour reading Howey, right? It's 5 pages of the casebook, right? So I just want you to you should develop this sense. This isn't for me. When a partner asks you to read material, you need to read efficiently, right? So I want you to kind of develop that sense. And if you feel like you didn't read something that we talked about in class, no sweat. I mean, if you took notes, you just follow your notes, right? You can go back and reread it again. You can come to office hours. We can talk about it as many times as you would like. So don't sweat it. I'm happy to go over the material as many times as you would like. But it's very hard to predict where the conversation's going to go exactly up front. All right? That's the best I can do, unfortunately. Other questions? Class mechanics. We're all on the same page. Yes, in the back. Do I have you now? No. Tell me your name.
I'm Laura. I also sit.
Oh, yeah.
I sit in a different spot somewhere else. So,
yeah.
In those initial emails that you send at the beginning of the week, which are great, could you flag the Texas Gulfs of the world?
Yeah.
Okay.
There'll be very few of those. But yeah, absolutely. If there's a case that I really want you to read carefully, like I did with Texas Gulf, I'll say to you, please read it carefully in its entirety, and I'll upload it as an attached Westlaw printout and ask you to really know it, right? And remember, the reason why I wanted you to know Texas Gulf wasn't because you're going to get quizzed on the facts of Texas Gulf, right? It was because Texas Gulf, the majority in the dissent articulated some very fundamental debates over materiality, over what kind of information we want to get out there. And the majority's sort of view that you can look ex post at trading behavior, or you can just sort of say, oh, it's obvious that this information should be disclosed, this is material because it was a way to make profit. I really wanted you to engage with the dissent's critique of that because it reflects 2 different views. You often hear people say, oh, cybersecurity breaches, of course they should be disclosed. Of course that's material because you can make money trading on it. Just wrote a paper that shows that, right? But maybe it's not so trivial to start disclosing cybersecurity breaches. What about food poisoning, right? So the reason why I wanted you to read Texas Gulf wasn't for the sake of Texas Gulf. It's because the argument there is a really fundamental one. It can apply to food poisoning. It can apply to all kinds of fun hypotheticals. So those are going to be unusual. It's rare that you have a case. Well, when we come back to BASIC and matrix, when we talk about materiality again in the 10b5 setting, you'll probably at least read BASIC. I can already give you a heads up. That's an important case to know. Other procedural questions. All right. So we have no projector. Okay. So let's look at as a result, I'm just going to have to kind of guide you. We're going to start now a section of the course that in the casebook, you see we go completely out of order in the casebook, like completely. There's no logic to it whatsoever. The reason is because I think it's more interesting to talk about questions concerning disclosure while we just sort of assume that we know what a security is. But formally, you should start with what is a security. Why should you start with what is a security? Because this is securities regulation, and it is the law governing securities. So what is a security is kind of important. However, most of the time, it's really clear what a security is. Section 2A1 of the 33 Act, which I have on the screen, and you do not see it, says the term security means any note, stock, treasury stock, security future, security-based swap, bond, debenture, evidence of indebtedness, certificate of interest, or participation in any profit-sharing agreement. Pause for the coffee midway. Collateral trust certificate, pre-organization certificate, or okay, this is transferable share, investment contract, really important one, voting trust certificate, okay, many other things. Any put, call, straddle, option, or privilege on any security. Where's my trader from yesterday? Oh yeah, okay, so you know what a straddle is, right? A straddle is a volatility, the volatility exposed option. Remind me your name one more time? Grace, yeah, Grace. Yeah, you usually sit over there, yeah, okay. So Grace was asking me this great question about volatility trading. So a straddle in the middle there of section 2A1 is a volatility option, volatility exposure. It looks like this, doesn't matter. Option or privilege on it, because you make money if the stock moves this way or this way, that's the idea. Or privilege on any security, certificate of deposit, or group or index of securities. All right, keeps going. Bottom line, most of the time, a security legally is a straightforward question. What is a security? A security is any one of these enumerated instruments. And if you are issuing stock, as the 33 Act contemplates, and we spent substantial time discussing, the stock you are issuing is unequivocally a security. Like literally shares of stock of a firm, of a corporation. Corporations authorized to issue shares. We've all now concurrently or previously taken corporations. A corporation issues stock. That stock is a security by the terms of 2A1. So most of the time, when you're talking about IPOs, there is no debate. I mean, never, when you're talking about IPOs, is there a debate over what is a security. Now, the problem comes up when we wonder whether securities law should be applied to other kinds of investment contracts. Now, I think the timing of this is really perfect because tomorrow your 0L compadres will be joining us for, at least some of them, for our class. And tomorrow we will do the famous, which has been the subject of several notes and conversations, the famous application of the Howey test to cryptocurrency, which is seems to be the hottest topic. We will ask whether Bitcoin is a security. So perfectly timed for Advertising Columbia. So we'll do that tomorrow. Today, I want to kind of lay some groundwork and think together about how we should decide whether an investment contract is a security. And we're going to learn the way, so we're going to do this in two steps. First, we're going to think as you would expect economically. Try to understand from an economic theory standpoint what a security is or should be, or why it makes sense to think of certain contracts as securities. And then we're going to apply, then we're going to turn to the law, and we're going to understand what the courts have done and the judicial doctrine in this area by and large. Because it turns out, as you read in the casebook, investment contract is not defined in the statute. So we have no idea what an investment contract is. Neither is stock, by the way, but we kind of know what stock is. What we don't know is whether Bitcoin is a security, whether ICOs are securities. And we don't know the answer to that question because, per the terms of the statute because the term investment contract is not defined. So what we're going to do is really start by thinking of the economic theories, like the rationales, as to why we might want to characterize a particular contract as a security. And then we're going to go to the law and see how the courts have grappled with the same questions, but applied particular tests that sometimes kind of make sense economically and other times reflect possibly a sort of formalism that is not necessarily connected to the economic reality. So how would an economist, let's start here, how would an economist think of a security? What would an economist say a security is? Well, you're law students, lawyers to be, not economists. Maybe some of you will do PhDs or you're doing JD MBAs. I know a couple of you. What is a security in economics? It is a contingent claim, okay? A contract whose payoff to the entitled party, to the holder of the right, is contingent on some random or unknown, you can think of them as the same thing, random to at least at today, state of the world tomorrow. Some unknown state of the world tomorrow is, you can think of that as a kind of randomness. I don't know if it's going to rain or be sunny tomorrow. I can put probabilities on it, but I don't know. If I have a contract that pays me if it rains tomorrow, economically, that is a security. That's how economists think of a security. Contingent claims. Claims, contracts, whose value turns on the realization of randomness tomorrow, realization of states of the world. You hear this term used. So a contract whose payoff depends on a state of the world realizing tomorrow is a security to an economist. Why am I starting there? Because investment in an economic framework consists of buying such contract today, that is, exchanging cash that you have, or gold, or some non-contingent asset. Could not only be, green dollars, but some other non-contingent asset, and exchanging that for a contingent claim, for a claim that pays off in some unknown state of the world tomorrow. Like, it could rain or shine. If I get paid if it rains, that is a security. If I spend $10 to get paid $20 if it rains tomorrow, I have exchanged $10 of cash for a contract that will pay me $20 if it rains tomorrow. That's investment in an economic framework. Okay? Now, to an economist, the regulation of securities is really the regulation of investment. It's the regulation of risk-taking. Does everyone see that? If I spend cash today to have a chance of a payoff tomorrow, which is what that means, if I have a contract that pays off in a contingent sense, and contingent on some state of the world realizing tomorrow, I have traded no risk for risk. Does everyone see that? It's very basic, but I want to make sure this is clear. So to an economist, the regulation of securities is the regulation of risk-taking, or of the acquisition, the purchase of contracts that expose you to risk. Bless you. Now, that's not exactly how the law thinks about security. We're going to, what is a security? And we're going to dive into that. But it is how the economists put. What is a problem with the economic definition of security in that sense? Well, you start to feel like, in fact, it could encompass a lot of things. I mean, risk-taking, which is what this intuitively means, is everywhere. Now, the economists would try to draw a distinction, would try to say, look, when I pledge my labor in exchange for a salary, that trade of labor for salary is not contingent on some state of the world taking place. It's not a risky gamble. You could quarrel with that. You could say, well, whether or not you can work might depend on whether or not you die tomorrow, which might depend on risks. But in a simplistic sense, you can try economically to separate risks that an economist would think of as sort of involving risk-taking or securities in the sense from other contracts by pointing to whether or not that contract is essentially a gamble. Again, you can push this, but avoiding the extreme edge stories of how everything is a gamble, let's just stick to kind of day-to-day contracts. You go and agree to work at McDonald's, and you're flipping burgers for $10 an hour. You're pretty much guaranteed that $10 an hour payment if you flip the burgers. And in a simplistic sense, we wouldn't think of that as a contract. So the economic test can separate risky bets from bets that involve kind of non-traded wealth. That's one way to think about it. The economists would say what securities are traded investment instruments. That is, they involve the transfer of risk between market participants. Somebody is willing to exchange $10 of cash for the possibility of $20 tomorrow if it rains. That means someone else is going to get $10 of cash and have to pay that $20. So to the economist, a security is really a transfer of risk. You're transferring who pays or gets paid in the event of something uncertain happening. And in many cases, you can point to labor market contracts, for example, supplier agreements. I promise to pay, I'll order the following goods from you and promise to pay within 30 days, doesn't seem to be contingent on uncertainty, right? In a simplistic sense. You have to be careful with how far you take that. Now, the problem, again, why that is not a useful test is that it would seem to encompass a lot of other kinds of non-labor, non-sort of definite contracts. For example, what about just simple business transactions where the payment in the transaction is tied to something out of your control? So for example, I am going to order as many, think of like a requirements contract. I'm going to order as many widgets as there is demand, as I require. Well, that sort of contingency doesn't, map nicely into this distinction because demand for widgets could, in fact, be very high or very low. And there starts to be a point at which an economist would say, risk transfer is enough to think of contracts as implicating the sorts of overpayment, underpayment considerations we've been discussing thus far. There comes a point where the lawyer starts to get bothered by that, right? The lawyer starts to feel that merely identifying some transfer of risk such that we would have potentially overpayment and underpayment of the kind we discussed at the beginning of the class, the lawyer starts to feel at some point that that stretches the definition of security really far and starts bringing into securities law any kind of risky contract. And it's for that reason that lawyers sort of think of securities law as having, it must be more limited than just risky bets. It must be restricted to something less than that. Now, you might try to say, well, securities law should be limited to investment in firms. But then the question is, what is a firm? What about a sole proprietorship? Can you issue a security as a sole proprietor? Well, the answer is probably yes. If I start a lemonade stand and agree with you in exchange for your $100,000 investment to open the best lemonade stand ever with an heated and cooled mobile food truck apparatus where we serve lemonade, I will give you a share of the profits. And this is just the Josh Schmitz lemonade stand, and there's no corporation. There's just a contract, a profit-sharing contract. It is very possible, I would say, in fact, almost unequivocal, that that agreement would be characterized as a security under the Howey test. My investor is investing in me, and the fact that I chose a sole proprietorship doesn't get me off the hook under the legal test we're going to study. So what this tells us, before we even dive into the definitions here and what we see in Howey, what this tells us is that lawyers have an intuition about what a security is that must go beyond risk sharing. It's got a risk transfer. It's got to be something more, something that feels like investment. Now, this should start to sound a lot like other open-ended legal tests that we've heard in securities law, where you kind of have an intuition, like in Omnicare. You have an intuition that, statements of opinion should be actionable in some settings, and you try to craft a regime because something bothers you about the hard and fast rule, but you don't really have a strong sort of a priori theory as to what the thing is that you're trying to capture. You just kind of feel uncomfortable with going too far in one direction or the other. That's really, I think, the best way to describe what is a security. It is a judicial attempt, and I think there's even a quote in here about, I'm not remembering now which case, about, what is it, like bumping up against the edges and the zipper, I don't know, but some sort of, the law is stitched when the fabric meets, I don't know. So there's something like that we're going to run into at some point, because that's very much the story here. Okay, so what happened in Howey? Well, tomorrow, with the 0Ls, we'll do true Legally Blonde style Socratic, and we'll call on Mr. and Mrs. someone in the class. But today I'm just going to tell you what happened in Howey for the sake of time. All right. So as you know, Howey, this is just the fun case of securities law. I'm depriving one of you from telling us all. Howey involves citrus groves, the development of citrus groves, units of a citrus grove development, more precisely. And the issue in Howey is that Howey and the Hills Service, Florida corporations, own a lot of acres, about 500 acres they've planted in Florida, and they are a service company engaged in the cultivating and developing of these groves, including the harvesting and marketing of the crops. So, you're a happy Floridian, or not, because I believe they used the mails or instrumentalities of interstate commerce, and you are told that you can buy an orange tree. Buy an orange tree. You can buy some land, and you get, along with that land, a service contract. And while the purchaser, the court reminds us, is free to make arrangements with other service companies, the superiority of Howey and the Hills Service, Inc. is stressed. 85% of the acres that were sold were in fact serviced by Howey and the Hills. All right, so after you pay, the land is conveyed to the purchaser by warranty deed. An acre consists of a row of 48 trees, so you buy, I guess, 48. Oh, well, yeah, you could buy as much as 0.65, so I don't know, so you might be able to buy 20 trees? 25 trees. Okay, so the service contract is a 10-year contract without a cancellation option, and what does it do? It gives Howey a leasehold interest, Howey and the Hills. So you basically go to Howey and the Hills and you say, if you service my orange trees, my citrus grove, I guess it could be lemons, but yeah, if you service my orange trees, I will give you a leasehold, I will, as part of this deal, that yields you full and complete possession of the acreage. Now this is actually kind of important because it implies that I'm really, as the owner of the trees, I'm really not even entitled to possess that land, right? You can think of it like a landlord who has leased out an apartment, so the possession and use, you took property, right? The use and possession rights are transferred under this agreement. And in fact, the court points out, without the consent of the company, the landowner or purchaser has no right of entry to market the crop. There is no right to specific fruit. So I can't just go check on my orange grove, see, here's a really cool orange, this one looks beautiful, I want to take it and eat it. Now, these are important distinctions, right, important facts, because they move this orange grove away from the characterization that probably Howey wanted it to have at first glance, which is that you've just bought a row of orange trees. I mean, if you bought a row of orange trees, you have acquired an asset that pays off in a state contingent manner, right? You've actually acquired orange trees. And we could quibble about whether that's a contract, but it's probably not a contract, but it's a physical item, physical good, a commodity that pays off when the weather is good, right? When whatever. So you could stretch the definition of security to fit just the acquisition of the orange trees, but that would be a real stretch. You could imagine a contract where you're contracting with Howie in the hills, and the essence of the contract is, these are my orange trees, but I want you to go in and water the trees and trim the branches, whatever, and prune the tree, and that's going to be our deal, and that's it. And that contract would also potentially involve a kind of risk sharing, because in a way, you are sort of offloading the costs of maintaining the tree, marginally at least, to Howie in the Hills with that basic service contract. But this service contract went a lot further, involved a lot more than just maintenance of the trees. And these are important facts that the court is bringing out. And again, I want to remind you that the legal intuition as to what constitutes a security or an investment contract, because we're under that prong here, remember, it's really more than the economic sense of risk transfer. It involves like a sense we have that it's no longer really about buying orange trees. And that's the idea that you want to keep in your heads throughout all of this, that the law in this area kind of centers on sort of this almost philosophical, kind of ontological, like, what is investment? Investment is something more than just ownership of trees. The purchasers, for the most part, are non-residents of Florida. They are predominantly business and professional people who lack the knowledge, skill, and equipment necessary for the care and cultivation of citrus trees. Again, these facts are kind of changing the nature of the transaction to the reader away from just buying orange trees. Notice, buying orange trees is a speculative investment in and of itself, right? Just merely buying the trees, and in fact, a contract to purchase the trees. Let's even more primitively start there. A contract to purchase the trees is in and of itself a contract that has a kind of state contingent payoff in it. None of that sort of risk transfer rationale is what the court is really focusing on. Okay? The court is focusing on something else, the sense that the purchasers aren't actually buying citrus trees. Not that the purchasers aren't buying citrus tree risk. Notice, that's the key point. The purchasers are buying citrus tree risk. That's clear. That's the nature of the deal. Whatever risks go into a citrus grove, the purchasers are exposed to. That's not the point that the court is emphasizing. All right, the hotel's advertising mentions the fine groves. Groves are for sale, great. It's admitted that the males and instrumentalities are used. The legal issue turns on whether or not this is an investment contract. Okay, page 263 of the casebook. By including an investment contract within the scope of 2A1, Congress is using a term the meaning of which has been crystallized by prior judicial interpretation. It embodies, at the end of the paragraph, a flexible rather than a static principle. By the way, if you're wondering how to read a case, this is how you read a case, right? I'm just taking even longer to explain it, but you should be able to get through Howie pretty quickly. Okay, the court then concludes the transactions in this case clearly involve investment contracts, clearly. All right? The respondent companies are offering something more than fee simple interest in land, something different. There's like a lot of this, like, it's somehow different. It's something different than a farm or an orchard coupled with management services. They are offering an opportunity to contribute money and to share in the profits of a large citrus fruit enterprise, managed and partly owned by respondents. They're offering this opportunity to distant, faraway folks who lack equipment experience requisite to the cultivation. They have no desire to occupy the land, develop it themselves. They're attracted solely by the prospects of a return on their investment. This is throwing out a lot of different stuff, right? Like, does that mean you have to be subjectively motivated by a desire to have a return on your investment? So there's some questions around this kind of reasoning, but okay. Let's go down more towards the bottom. A common enterprise managed by respondents or third parties with adequate personnel and equipment is therefore essential if investors are to achieve their paramount aim of a return on their investment. All the elements, next paragraph, of a profit-seeking business venture are present here. The investors provide the capital, the promoters manage. It follows that the arrangements whereby the investor's interests are made manifest involve investment contracts, regardless of the legal terminology. The warranty deed and the service contract become together then an investment contract. All right, so that's Howey. Three-part test, right? What is the famous Howey three-part test? Well, it's given to us in Brod v. Bachet. I don't know how you say that. An investment of money in a common enterprise with profits to come solely from the effort of others. So Howey gives us a three-part test. Investment of money, common enterprise, profits to come solely from the efforts of others. We'll see, of course, that solely kind of gets relaxed, common enterprise. So the law here evolves like typical legal doctrine evolves, kind of carving out niches and nuances, which we'll look at. But just start there. Okay, an investment of money in a common enterprise with profits to come solely from the effort of others, or let's just say from the effort of others. Now think back to the risk transfer paradigm that we started with, and you can kind of see how there's some overlap. So the idea that the profits come from the efforts of others reflects in exchange for money, reflects a kind of risk transfer. So one way to view the Howey test is an application of the economic framework that we discussed, whereby the sorts of risks that constitute securities in an economic sense are narrowed down so that legally we only characterize a particular sort of risk transfer as a security if it involves risks where I, as the buyer, am not putting in any effort or not putting in a substantial amount of effort. Is this clear to everyone? That's one characterization of the Howey test. One way to view the Howey test is a judicial attempt to limit the scope of securities law to economic securities that involve no effort on the part of the buyer, or very little effort. And one way to think about that, like why that maybe makes sense to lawyers, is that there's this intuition that if I'm expending effort, then I probably am not investing. Like investment in the mind of a lawyer seems to involve spending money and waiting to see if the risk realizes in my favor. Whereas when I put some effort out there, I am not engaged in the same sort of risk speculation or risk transfer. Now that's the ex post rationalization of Howey. Now, what I want you to start to think about, and what will come up over and over again as we look at the application of the Howey test to various settings, is whether or not these criteria accomplish anything. Like, what do they accomplish? What this limiting of the scope of securities law to contracts where, as the buyer, I put in little effort, that limiting may or may not serve any function. It may serve a function in some settings and not others. But this is really, if you think of the case law around Howey, the central issue. That is, it's very hard to articulate what goal these elements serve. But this is our intuition. This is our intuition. Is this material clear so far? I want to make sure everyone understands kind of what Howey is doing. It's starting from this economic idea of risk transfer, but it's limiting the scope to those cases where I really didn't put in much effort. There's a further limitation in the second prong, that my investment needs to be in some kind of common enterprise. Now, we'll look at the cases shortly, that can be sort of viewed as a vertical commonality, which means that in the end of the day, the Howey test is going to be read to allow common enterprises between essentially the buyer and seller. And so, again, it's trying to pick up on something, but it's not always clear what that something is. So the casebook talks briefly about this idea of unique investments, all right? So I'll just read here. Both in Howey and Joyner Leasing, the term investment contract was applied to arrangements that were not susceptible to trading on exchanges or in other securities markets. Now, why is that interesting? Well, if you think about the economic, again, idea of a security as involving risk transfer, contingent claims, those contingent claims should, in principle, be alienable, be tradable. Because there must be, if I'm willing to pay you $10 if it rains tomorrow, there must be a price at which you'll buy that from me, and someone else must be willing to buy that from you at a particular price. Like, the intuition here is that risk transfers of the sort that involve contingent contracts, like economically, like we've been describing, tend to be liquid and tradable. And so you might wonder whether liquidity is a good test, because that might come closer to picking up the sort of contracts that we would like to be characterized as securities. I mean, if a contract is contingent on something idiosyncratic to me, like my own personal performance, it starts to feel to us like somewhat removed from the kinds of contracts that securities law should be caring about. I want you to notice the sort of clumsiness and awkwardness with which we're talking about this. Like, there's something that we think securities law should be caring about, and it kind of seems like it should be like the sort of instruments that are traded on securities markets. But this is the problem with this area of law, okay? There isn't a clear normative goal articulated from the outset that we're trying to accomplish. Instead, we're trying to capture, as the court said in Howey, right? We're trying to capture this this flexible rather than static principle. There's a quote here: many types of instruments that in our commercial world fall within the ordinary concept of a security. And what the casebook points out is that the court has backed away in the Marine Bank case from applying this term to some forms of unique business arrangements that could not be traded in securities markets. And one of the questions you should ask yourself is, I mean, if a company writes a very bespoke, highly customized agreement that involves no effort on the part of one of the parties, but an investment of money, you can imagine many joint ventures would fall into this category, right? So we agree, that, Amazon is going to pay Netflix a particular amount of money to show Netflix content on Amazon. And in fact, that involves very little effort on Amazon's part. It's a common enterprise, and the success of which the profits will come solely from Netflix's effort. So there's a sense, though, in which an agreement like that between Amazon and Netflix to show content on Amazon VOD is probably not a security. But it's just like a sense, right? Questions on this? Is this clear? I want to make sure that the building blocks here are clear before we get into the weeds. Yes, Alistair.
Even applying that test in like a narrow way, doesn't that still have? It's like, I'm thinking of an example like if I buy like a signed baseball, signed by Babe Ruth. I'm investing money. I have, whatever the vertical common enterprise between me and the seller. And any change in the value isn't going to be coming from me. It'll be coming in whatever the memorabilia market's doing. So that's a third party. So why doesn't something like that fall under securities law? Because presumably that's not under the Howey test.
Right. So the value of a product is often set by others. You might contort this, right? So commodity. Yeah, so the classical view of the baseball. So if the baseball is a commodity like corn, so the more typical example might be I buy corn. Corn is a commodity whose value will fluctuate. And one of the big challenges in this area classically was separating out commodities from securities, because there are certain kinds of commodities, like a contract that pays you if it rains, like a weather derivative, that would seem to be much closer to the definition of a security even than the baseball example. But the logic is really the same logic. It's the same problem. So as a matter of law, I mean, the way that a lot of people analyze these questions is to start with whatever they think the outcome should be. So intuitively, I don't think a baseball is a security. Intuitively, I don't think corn's a security. Intuitively, I probably don't think a weather derivative is a security. Probably. So I'm going to apply the Howey test. Okay, this is what you'll do in the practice of law. I mean, this is how a lawyer would approach it. Well, you know, is that really a common enterprise? You know, is there really vertical commonality in the sense that it's not an, I mean, there's no effort on the part of my counterparty. So one formal black letter law approach is to say, you know, the baseball, the corn, the derivative doesn't really involve effort. So it's not, there's zero commonality. There's no enterprise. It's a purely speculative bet. Now, yeah, I don't know. You know, what about an option? Well, an option is explicitly in 3A, so 2A1. So an option, what about, you know, a contract between us that is in some way conditional on some kind of market, some kind of other market realizing. And then you start to wonder whether that might make its way into the Howey test. So you're absolutely right that this is an area where creative lawyering is common. But in this particular example of the baseball or of corn, one of the problems you're going to have is the commonality. Right? You're going to have a problem. There's no enterprise. There's no common enterprise. Also, it's not clear that the profits are coming from the efforts of anyone. Right? So a purely speculative gamble that pays off whatever the market value, you would have a hard time articulating as involving the efforts of anyone. Right? So the Howey test is trying to loop in contingent payoffs, contingent contracts, state contingent contracts that involve some kind of firm, right? That's another way to see this. There's a sort of firm theory kind of built in here, that it's got to involve effort, it's got to involve some kind of collaborative effort, or effort collaboratively in the sense that I'm paying for someone else's effort in an equity investment sense. What about debt? Let's take a debt. Let's practice applying this definition on its terms, and we'll worry about some of the case law in a bit. Let's just make sure you see how flexible and messy this is. What about a bank loan? So a bank gives you money. A bank gives you money, and the bank is going to get a profit on that money. So the bank lends you $100,000 to buy a house. The bank's expected profit from that loan is the interest that you're going to pay. If you're going to pay 5% a year on that loan, the bank can expect a certain, you know, $5,000 the first year, and then it's going to decline a little bit each year, but there's an expected profit. So if the bank lends you money, there's an investment of money. There is a sort of enterprise, right? The enterprise is you have to maintain your house and live in your house and make your mortgage payment. In a way, you can view a loan, a bank loan, a mortgage, as an investment in you and your house, right? All right, let's take a better business loan. This gets even easier to see, right? A bank makes a loan to a business. Now here it should be very clear to you, particularly if you've taken corporate finance, the payoff, the profits to a loan to a business depend entirely on whether the business stays away out of bankruptcy. So the payoff to a bank loan to a small business is the profits are entirely driven by the efforts of the entrepreneur. Debt is an investment of money in a common enterprise right? The commonality is actually no different from the Howey case. The only difference is that the contract provides for a regular payment rather than the equity appreciation, rather than some resale value, or rather than whatever the orange trees happen to produce. Debt is just the exact same contract. You could take the facts away and replace the profits to the investors, replace the oranges or the sale of the oranges with a coupon payment, a payment every month. That is, Howey sells the oranges and pays the buyers $1,000 a year or $100 a month or whatever number you want. And every other fact of Howey would be the same. And you would have a security, would you? Is debt a security? So who can articulate, based on our conversation so far, we haven't sort of dug into the law, there's some law on this point, but I just want you to get the intuition, because you're not always going to be able to point to a particular case that has decided that bank loans are not securities, right? That's easy. I want you to think about how you would articulate the claim that a bank loan is not a security under the Howey test. What is it about the Howey test that's not getting picked up by a bank loan? Yes? Andrew. That last part's pretty important, though. Really important, right? So you're right, I'm with you all the way to the last part. Because if the bank goes bankrupt, if the firm goes bankrupt, the bank gets nothing, or cents on the dollar. So the expected profits are going to be discounted by some probability of going bankrupt. I think there's a 10% chance you're going to go bankrupt. That investment is worth less than if there's a 1% chance you're going to go bankrupt. Other characters. So it's right, but there is this problem that the bankruptcy risk. Yes. Oh, so so Andrew said that the reason why the bank loan is not a security under the Howey test, like let's keep it at the intuition for a minute, is because the profits don't really come from your effort. So because it's a fixed payment, the profits and that fixed payment are not driven by your effort because it's a fixed payment. My response is that, in fact, the probability of the payment does depend on your effort, because if you don't put in a lot of effort and the firm goes bankrupt, the bank gets nothing. Moreover, 2A1 includes a note, a debenture, and an evidence of indebtedness. Expressly by its own terms in the definition of a security. So I'm just having fun with you. I mean there's a certain this is not clear. Yes. Let's walk through this. Let's just break it down. So I go to a bank to get a loan. I'm a small business person. I say, I want $100,000. I want $1 million. From the bank's perspective, that loan is a payment of $1 million, let's say. And the bank, at that point, has an expectation as to what it's going to get in profits from giving me that $1 million. So we're looking at it from the standpoint of the bank, and we're saying the bank is buying something. That's the way to think about it. The bank spends $1 million, actually expends $1 million, hands it to you. Now the bank has bought something. It's no different, intuitively, from going out and buying a house or a piece of real estate for $1 million. Now your point is, okay, so the bank buys something where the efforts don't come from the bank. Right, generally in investment, the buyer, the investor, spends money, and the gains that come back to that, the profits that come back to that investor, come from the recipient's effort, whoever receives the money, right? So if you make an investment in the orange trees, you spend $10,000 as a Floridian resident, you put out the $10,000, and it's Howie's effort that, in fact, determines your profit. If Howie puts in a lot of effort, you walk away with a lot of money because the orange trees do well, they sell for a lot, and you keep them. So the way to think about the bank here is like the bank is like the Floridians in this story. The bank is putting the money out there. So the effort of others that we're talking about, who's the others? The other is the recipient of the money. The recipient of the money here in this hypothetical is the business. So it's sort of just like an equity investment in that business, but for this distinction that perhaps the guaranteed payment kind of changes the characterization. Does that make sense? Do we agree on that?
Yeah, I guess I was just looking at like who you were trying to promote.
Right. So we're going to think of the promoter as the recipient of the cash here, right? Whoever wants the cash, yes.
So I'm just trying to think through this and thinking about Alistair's baseball example.
Right.
So say that you're an auctioneer and I buy a signed baseball from you and say, hey, in 2 years I'm going to auction this through you. You can get 10% of that. And now say instead of doing that, you came to me and said, hey, I've got this opportunity to buy this signed baseball. If you fork over the cash, I'll auction it in 2 years and give you 90% of the proceeds. The exact same things are happening, but one seems a lot more like a security than the other to me.
Right. Well, right. Great. So let's make sure everyone understands that. I can buy. Let me just abstract it a little bit. I can buy your effort, or I can sell you my effort in a way. I mean, you can think of it like I can agree that you sell it and give me 10%, or I sell it and give you 10%, or 9. I mean. So there have to be, so the logic of the contract would require some compensation for effort. But I think your point is if you flip the effort, who puts out the effort in a lot of two-way deals, like sort of bilateral gambles in a sense, like you could just flip who expends the effort. And that seems to change the characterization intuitively and also under the Howey test. Typically in most markets, my ability to sell or the auctioneer's ability to sell, the ability to expend effort is kind of not freely exchangeable. So if I'm a really great lawyer, like it's hard to write a contract with a non-lawyer where the non-lawyer would expend effort, right? The same kind of effort that I would. So one of the challenges, or just like in the bank example, it's hard to turn the bank into the small business or turn the Florida buyers into Orange Grove companies, right? So often, who is able to expend effort is kind of given. Now, there could be situations where there's just a pure risk transfer, and that kind of really pushes the Howey test to its limits. And I think that's where you're going. Those would be probably rarer. Yes, Magdalena.
I'm wondering if you were to compare and distinguish it from bonds, right, which are issued
Yeah.
by the company.
What's the difference?
But that's the question.
Yeah.
What would be the difference?
What do you guys think? What's the difference between a bond and a loan?
Because the difference, like, on one side we have banks, which is a professional institution that did
Right.
bonds. On the other side we have, like, individual investors.
Right.
investing in bonds. But in principle, this is all debt, and this is
Right.
like, principle might be very, very
Right, right.
Could we treat the bank loan more like commodity type of transaction compared to
Like corn? It's like corn and wheat?
yes?
It's a bank loan like corn and wheat.
Money like they would use corn and wheat, basically. Whereas in bonds, it's a little bit different because the individuals are kind of doing that.
So, great. Great. So Magdalena makes this nice point, which is like maybe bank loans are like commodities. So at first, I think my initial reaction to that was to say, well, corn has it's like a head of corn, right? It's just, it has a price. And a loan involves all sorts of idiosyncratic circumstances, like whether or not this buyer is, this seller, to make the point, right? You're selling essentially as the recipient of a loan. Whether or not this borrower is going to repay would depend on all sorts of idiosyncrasies. On the one hand, there's something that I resist that characterization for that reason. On the other hand, how many of you are familiar with mortgage-backed securities? On the other hand, so your home loan is actually resold. And it's resold because it actually is a standardized contract. It is not a security. It is purchased on a secondary market for home loans, generally by Fannie Mae and Freddie Mac. In the case of loans that conform to certain criteria, they're bought automatically by the GSEs, Fannie and Freddie, the government-sponsored entities, and they sort of immediately purchase. But then what do? Well, they package all of those loans and issue mortgage-backed securities. Now, the fact that you can now those are unquestionably mortgage-like securities. They are actually the stock of special purpose vehicle entities. Those of you who understand how this works, they are sometimes more complicated configurations, but by and large, these mortgage-backed securities consist of equity shares of entities that hold as assets the loans. That is, Fannie and Freddie pay a particular amount to a bank in cash and in turn receive the cash flow rights, meaning every time you make a payment, those payments are actually sent to Fannie and Freddie, or whoever is whoever securitized the loan. And so the ability to purchase and repackage, in fact, is closer to this characterization like a commodity. There's a sense in which the loan itself might be saleable. Now, that works for home mortgages, which are standardized instruments. So that argument turns on the standardization. Go ahead.
But even for other type of loans, where like the project finance, you have some like arrangement, right? And then you can, banks will usually want to get rid of the loan from the balance sheet and this was
Right.
market and trade.
Right. So, but of all the justifications for, like, just to play with this a little bit more, just to push this, of all the justifications for treating bank loans differently than bonds, than debt securities, the fact that they are then repackaged and sold as securities seems the least convincing to me, because they're treated just like securities in the end, just as a group. So so I think most people would resist that characterization because they would say, well, if anything, that weighs in favor of recharacterizing them as securities. After all, they're just bought and resold like securities. So the disclosure concerns of overpayment and underpayment, information, informed trading, the whole ball should apply to trading in the mortgage-backed securities. Of course, it does, but why would we not carry that through to the mortgages? Okay, that's a nuance. Let's not get stuck there. But more broadly, I think a lot of people would say, look, the reason why bank loans are not thought of as securities is because banks acquire a lot of relational, sort of soft information, it's called, about the borrower. You go out and they observe the borrower's business. They sort of learn a lot about the borrower. They make a loan based on some effort that they expend. So this would be the legal sort of prong to kind of push this in, which is that banks kind of do expend effort. This is a product almost that they offer, a service that they offer, and that might be the best way. There's also just a historical sort of rationale. But if you think about, like bank loans were just kind of always not thought of as securities, and in this area of law, history matters a lot. If you think about a bond, though, there is a rationale that a bond. What is a bond? A bond is just a corporation saying to the investing public or to some investors, if you buy this bond, meaning if you loan me money, I will pay you back on these terms. It doesn't involve any effort on the part of the purchaser. So one way to distinguish debt is to try and pin it down on effort. A lot of this goes to historical idiosyncrasies. Let's talk in the last 5 minutes about Brot v. Bache. And here, again, the key, just another exercise in reading, okay, you have one paragraph of facts, but this is the sort of thing that you should be able to just get the bottom line very quickly, all right? It doesn't really matter what the facts are because the court is sort of making very clear what happened, what the holding is. Our definition rejects, this is the Ninth Circuit, our definition rejects any requirement of horizontal commonality in favor of only vertical commonality. So the issue here is we have a brokerage house and a commodities trading account. And the reason why I'm not spending time on the facts and why, again, you should develop this intuition is that the point of the Brot case is that you don't need to establish horizontal commonality. This, the court makes clear, meaning you don't need to show that the fortunes of the investor are interwoven pooling of interest with other investors, right? That a discretionary commodities trading account under this view of vertical commonality is all you need to show is that the buyer and the seller have this common interest in the success of the enterprise. The point here, again, just trying to help for those of you who feel like you're lost when you're reading, the point here isn't to worry about whether a commodities trading account is a security, right? That's not the point. The point is that you shouldn't be too concerned about the absence of horizontal commonality. You should point out that at least under Brot v. Bache, there is no requirement for a at least the kind of horizontal commonality, let's say in general, right? Now, again, there is always going to be some room to play with in these facts. I mean, you can imagine cases where, let's put it this way, it's very rare that an investor is investing in a completely isolated fashion, such that there's no other investor out there. I mean, most of the debates around whether an investment contract is a security inevitably involve more than one investor and some kind of pooling. So again, try to think intuitively, is this really like, what is the point of reading a case like this? It's to remind yourself that it's not, you shouldn't pin down your analysis too tightly around the absence of horizontal commonality. First of all, it's almost always likely to be there. Second of all, as you see in this example, courts are reluctant to not find a security when all other elements are met, and the only one is that maybe you can't identify another investor who has pooled their risk with you, okay? So again, when you're reading, have an eye on like why this matters, right? That's what you want to develop, this intuition for why this matters. Again, the point here that the court emphasizes, and we'll wrap up with this for today, I'm just going to read from 199 of the Reader, or 27 on the top page of the page. In the instant case, this is the second full paragraph, the investor's return, while specifically determined by the commodities market, is also clearly affected by the expertise of the person doing the trading. Carmen, this other case involving, doesn't matter, can be distinguished from the case at bar because the success or failure of Bache as a brokerage house does not correlate with individual investor profit or loss. On the contrary, Bache could reap large commissions for itself and be characterized as successful, while the individual accounts could be wiped out. Here, strong efforts by Bache will not guarantee a return, nor will Bache's success necessarily mean a corresponding success for Brot. Weak efforts or failure by Bache will deprive Brot of potential gains, but will not necessarily mean that he suffers serious losses. Since there's no direct correlation on either the success or failure side, there's no common enterprise. Again, what the point of a case like this is to draw your attention to what matters in the Howey test. It's not vertical versus horizontal commonality. Generally, that's not going to be the issue. And this shows you how the Howey test, again, is sort of hollowed out and used creatively to get at what we feel like should be a security. What we feel like should be a security is something where my returns are in fact tied to someone else's effort. And the idea that a trading account where the gains or losses are not driven by the brokerage performance but by my own investment decisions doesn't seem to fall into that category. Bear in mind how this might change if you have an investment advisor who exercises some discretion in the allocation of investments. So you want to keep in mind how this rationale might counsel differently if, imagine, Goldman Sachs is choosing the stocks of those who participate in some kind of investment portfolio. Often, in fact, mutual funds are themselves issuing securities precisely for that reason. We're not going to discuss investment advisor regulation. That's under the 40 Act. But I just want you to get a sense for how you might alter the facts a little bit and still find that there's, and reach a different conclusion, because the key element of this commonality or this correlation between efforts might in fact be present in some cases and not others. All right, it's 12 o'clock. I can talk to a few of you with questions now if you have them. Otherwise, I'll see you tomorrow morning or at office hours at around 1:30ish. See you then.